Hello, and welcome to Enoch Keever's Case Spotlight. I'm Craig Enoch, and the case we want to spotlight is Texas versus the Environmental Protection Agency. This was a case recently decided by the federal D.C. Circuit. Now, after the United States Supreme Court agreed that under the Federal Clean Air Act, carbon dioxide and other greenhouse gases were air pollutants, the EPA issued extensive permitting rules subjecting power generation plants and other stationary sources of the gases to new regulatory controls. Further, the EPA determined various states' air permitting requirements were inadequate because they did not incorporate the newly regulated greenhouse gases into their state regulatory scheme. Texas challenged the new EPA rules, and while Texas agreed it had to update its state regulatory plan, it insisted it could continue issuing permits without considering greenhouse gases until, through the state's administrative process, it was able to update its own regulatory scheme. The D.C. Circuit disagreed, and its recent decision has immediate consequences for Texas power generators. The important point is that the court held Texas-like standing to challenge the new regulations because the regulations did not harm Texas. Texas had argued that the EPA rules directing the state to immediately begin regulating greenhouse gases violated the state's administrative procedures, like providing notice and a chance to be heard before rules are adopted or revised. But the court determined the state had failed to show how the EPA's action caused the state any actual harm. The court reasoned that the Clean Air Act had already required pollutants to be regulated and the permitting process had already been established. The fact that greenhouse gases were determined by the U.S. Supreme Court to be a pollutant under the Act did not fundamentally alter the EPA's regulatory scheme. Rather, the decision just brought greenhouse gases into that scheme. And in a bit of ironic logic, the court concluded the new rules did not harm Texas because they benefited Texas. In short, the emission of greenhouse gases would otherwise be prohibited by the Clean Air Act. And without the EPA rules, industry could not obtain the permits necessary to continue in operation or construct new facilities that, as a byproduct, produced CO2. So what does this mean for our Texas power generators? Two important things. When a gas is determined to be a pollutant, the gas immediately comes under the regulatory regime. Consequently, the Act prohibits construction of a major emitting facility without a permit. And while the Clean Air Act may pay lip service to giving the states the first opportunity to regulate its industries and air pollutants, any state process for notice to stakeholders or any opportunity to be heard is bypassed. For greenhouse gases, then, according to the D.C. Circuit, industry attention must turn to Washington regulators. The states are merely implementers. Texas versus EPA is our spotlight case. I'm Craig Enoch with Enoch Keever, a voice for business at its intersection with government.